So we have here, I think, the only British lawyer in the room, Joanna. So this is an opportunity to hear from someone.
I think the only British practicing lawyer.
Oh, okay.
Lord Justice.
Well, we have a Lord Justice. He's not a lawyer. So anyway, who can tell us what it's like in the pit, so to speak?
Well, I've enjoyed the conference enormously too, and my learning curve has been very steep in terms of the neuroscience that you've all been talking about over the last day and a half, and I'm very grateful to be invited to speak here. My brief was to reflect briefly on the perception from the English point of view in terms of a practicing lawyer. And I suppose last night I let all the talks that I'd heard overnight percolate through, and this morning I came to the conclusion that there were really, without repeating what people had already said, two relatively interesting, I hope you'll think, points that can be made about what's going on in England. Before I do that, though, I should say that I agree wholeheartedly, and this chimes with my experience with what Nick Rose said yesterday about the potential use of neuroimaging in the UK, and I'm not going to repeat that now. The conference, it seems to me, has been focused entirely on neuroimaging in terms of neuroscience. And I can see why. I mean, there's a huge amount of research going on here and indeed in England, but it appears that you're in the vanguard here in the States. So what I've sought to identify is areas in the UK where we've been doing interesting neuroscience, which is in fact being used in the courts, and I think being used in the courts in a way that it's not here. And this is in the context of SUDI cases, sudden unexpected death in infancy cases, and non-accidental head injury cases, where we are deploying developments that have been made over the last really 2 years plus perhaps in neuropathology, pediatric neuropathology. Now, these SUDI cases and non-accidental head injury cases, of course, are the subject of febrile debate on both sides of the Atlantic, highly controversial cases, which is why I highlight this area of neuroscience that's been going on in the UK, because it is, to me, very important. It's a very important development. If I can explain briefly what it is, the issue in a lot of these cases is whether or not there is evidence beyond the triad of findings. I'm sure you're all familiar with the concept of the triad in shaking cases: encephalopathy, retinal hemorrhages, and subdural hemorrhaging. And the controversy has been whether or not the triad is diagnostic of shaking when there are no external injuries on the baby at all. And I think it's safe to say that the conclusion that we've come to both sides of the Atlantic is that unless you've got particularly good triad evidence, and I won't bother to explain what that means, but particularly significant elements of the three elements of the triad, which taken together with the clinical context and the factual context are compelling, you need something more than the triad, and this is why this development in pediatric neuroscience, and particularly pediatric neuropathology, has been so important. It's been developed at King's College Hospital and indeed in other centres in the UK. And what in essence the researchers have discovered is that it is possible to identify in certain babies, not all of them, whether the child has in fact been the subject of a trauma by taking slices from the dead child's brain, particularly from the corticospinal tracts and the cerebellum, and submitting them to certain tests, the beta-APP testing, which can identify traumatic axonal injury as opposed to axonal injury caused by hypoxia. And this is an extremely important development. You can't tell if a child hasn't been the subject of a traumatic incident. I'm talking about shaking, of course, here, but you can tell in some cases if it has. And that is because you can see certain things on the slide, very impressive pictorial representations, which we have to be very careful about in the same way that we do about neuroimaging, which can indeed have a huge impact on the jury and can go beyond the triad. Now, that is something which I don't think you've been looking at, and certainly not using in the courts in the States. And the reason I say that, somebody may correct me, is that first of all my experts that I work with in London tell me that. But also I read a very long article by somebody from Yale Law School, published in the New York Times, 17 pages, on the 2nd of February, which went right through from Louise Woodward onwards to the present day, with a number of high-profile cases here in the States. And this particular technique wasn't mentioned once, and I can't believe that in none of those cases would there have been an issue as to whether or not the child had died from traumatic injury. So it's an extremely important development. In my view, it may be very narrow compared with the big subject you've been talking about over the last day or so, but it's important. The second brief point, if I'm allowed to, if I've got time, is the development in relation to expert evidence. Now, in the 80s and 90s, most of the notorious miscarriage of justice cases in the UK were as a result of failures of disclosure in IRA terrorist cases. Unfortunately, after those matters had been resolved by a new regime relating to disclosure, the most notorious miscarriage of justice cases in the UK have been, unfortunately, cases in which flawed expert evidence has been called, specifically in the context of SUDI cases and non-accidental head injury cases. Angela Canning, the Sally Clark case, some of you may be familiar with these cases. Sally Clark was a solicitor who was, a lawyer that is, who was convicted of killing her two of her three boys. Now, these cases have generated a lot of febrile debate in the UK, and indeed endless guidance and indeed changes to the procedure rules in relation to expert evidence. But the interesting thing to me is that throughout that time we have, in contrast to the States, we have a rule which requires experts to have an overriding duty to the court and not to the person who's calling the expert. And what's more, the expert is required to make a declaration in their report that they understand this, and it's something which is often discussed in conferences with counsel before they give their evidence. But in spite of that difference between your system and ours, we have still had these terrible miscarriage of justice cases caused by flawed expert evidence being called. So the simple point that I want to make here is that, and I'm afraid I don't know how you do it here, but the important point is two developments, really. There are two developments, really. One is the emphasis now on expert meetings prior to the trial. Very important indeed, very useful. They eliminate a huge amount of wasted material, confusing material being delivered to jurors, the fact finders, or indeed judges if they're the fact finders, so that the real issues are focused on. Very important development indeed. And the other development is, and I'm going to turn, if I may, to my notes here. The other development is the emphasis on guidance, which has been produced by the prosecuting authorities, the royal colleges, and so on, guiding experts in how they should conduct themselves in the context of these very difficult cases. And I'll give you a flavour of one of those pieces of guidance, if I may. It's quite old now, it's 2004. But this is the Kennedy report. Baroness Kennedy, she chaired a working party that looked very carefully into SUDI cases. And she said, "It's important that the courtroom is not a place used by doctors to fly their personal kites or push a theory from the far end of the medical spectrum. The expert should have recent clinical experience, peer-reviewed research, and should not roam outside his area of expertise. Doctors should say, 'I don't know,' without shame and inhibition. Now, that is guidance which unfortunately has not been complied with in the number of cases where experts have given evidence recently. There's a case that Lord Justice Hughes will know very well called Burridge, in which, frankly, I have never read a judicial condemnation of expert evidence like that before, ever, in which the expert was described as arrogant, ill-informed, obfuscating, and so on. A terrible indictment, in fact, of the advocate who called him, although in that particular case there were mitigating circumstances because he was called at the last minute. But nevertheless, that guidance is not being applied and complied with regularly in the courts in the UK, and clearly it does need to be. The other development which I think is interesting is that the experts have to, and this is comparatively new, they have to describe in their reports in the criminal context where they stand within the range of opinion. You could receive an expert report in which you would simply get the expert's view on whatever it was that the expert's reporting on. Now in the UK, what we require the expert to do is say, look, I am right at the furthest extreme in the opinion that I'm offering you, but I nevertheless say that I'm right for the following reason, or I am part of the mainstream, And the evidence I've been asked to consider by the other expert, in fact, is right out at the extreme and is an illustration of kite flying or whatever, for the following reasons. Now that, I think, is a very important and useful development for us lawyers. So those are my very brief observations from Planet UK in the context of the very esoteric subject matter that you've been producing over the last one day. Fascinating, and I'm very pleased to have been here and to have heard it.